First case today is State v. Smith. A couple of quick notes before we begin. We've allotted prescribed time to you, but if we're still asking questions when your time runs, go ahead and continue to respond. And don't bother with asking permission to continue to respond. That may mean that at the conclusion of the argument, one side will have had more time than the other. Not a reflection of how we value your case and your arguments, but how many questions we happen to have had with respect to your issues. Okay, I think that covers the preliminaries. Let me have you enter your appearances.
Michael Palumbo for the state.
Welcome, good to have you with us.
And Talaferro for Mr. Smith, the appellant.
Welcome as well. Okay, let's begin.
May it please the court and counsel, we have argued that the trial court erred in failing to dismiss 35-year-old allegations when it could not find by a preponderance of the evidence presented to it whether the prosecution was barred by the statute of limitations. As we noted in our reply, Mr. Smith and the state agree, or at least the state has not, or has assumed some issues or has conceded some issues, a majority of the questions we raised in our briefing. But I fear that it can't be that simple. And because as I was preparing, I found that there to be a lot of nuances within the issues that we raised. And some things have not been decided by an appellate court, and some things have not been decided by this court. Despite any concessions by any party, the court will probably want to explore some of these nuances. The one easy issue that I think is clear that we both agree on is that the applicable statute of limitations in this case. The limitations period applicable to sexual abuse of a child in effect when it is alleged that Mr. Smith abused CR in the 1988-1999 time period, limited prosecution to 1 year after report to a law enforcement officer, so long as not more than 8 years has passed.
Can I interrupt for a second and
Yes.
just jump you to a question
Yes.
that I have? Assuming we agree that there was error down below, why isn't remand the appropriate remedy?
The reason that we don't believe remand is the appropriate remedy is because all of the evidence was before the court and is before the court now. The state had multiple hearings, multiple times to present the evidence in what we believe to have been the state's burden to show that the statute of limitations had not run. There were several hearings. The state did what they could. And even the defense put on evidence to show that the statute of limitations may have run. So before the trial court was all of this evidence, and that same evidence is before this court. So the state argues that a remand is necessary for the court to apply the proper standard. This court, it's a legal standard. And so if the court, our argument is this court can apply that standard to the body of facts before the court. If the court does remand, though, I would ask the court not to allow the state yet another opportunity to yet present more evidence if they have it. They've had multiple opportunities. There's abundant evidence before the court, and I think it's just I don't want to say simple because nothing's ever simple, but it's a simple legal issue of whether this body of evidence amounts to a preponderance of the evidence that the statute of limitations has not run.
But presumably if, let's say that the district court didn't err and it was okay to let it go to the jury, the state would have been free to present additional evidence to the jury in that instance, wouldn't it have?
Sure.
Okay, so why wouldn't the appropriate remedy here to be remand and then sort out whether there's additional evidence to be presented?
Because if the state was allowed to present additional evidence to the jury, the burden's different. Right now, they're supposed to present evidence by a preponderance of the evidence. Statute of limitations is meant to, I guess, protect against stale allegations. It's supposed to protect the defendant. And so if they can't even meet the burden at this point by a preponderance of the evidence to show that it was not, that the statute of limitations was not, that their prosecution isn't barred, then it should be dismissed at this point in protection of the, in protection of the defendant and the protection of everybody. Because if they can't present evidence to show that their statute of limitations hasn't run, then how is a defendant supposed to present evidence against the allegations? Because the allegations were so stale. In kind of the reverse of that, however, if the court does find that there is a preponderance of the evidence and that this prosecution should go forward, I think that it could be a jury issue that they would then have to show by beyond the reasonable doubt standard, and that would be to the benefit of the defendant in light of the idea that statute of limitations are sometimes considered kind of an affirmative defense. So, I mean, if that answers your question.
Why should we make that, oh, sorry. I'm following up on this. Go ahead. Why should we make the decision about the evidence rather than letting the district court judge decide if she wants to take more evidence?
The court has already decided the standard on the evidence that has been presented to her. Judge Streese found that based upon the evidence presented, knowing the burdens, based upon the evidence, she could not, it was not clear whether or not the statute of limitations had run or hadn't run. That was her statement. We equate that statement, I don't know if this has run or not, to the failure by the state to present sufficient evidence to prove by a preponderance of the evidence that the statute of limitations has not run. So I believe that she has already made the finding about the sufficiency of the evidence that she needs to. It's just that she believed that she had discretion to push it off into, to the jury, as opposed to.
If she were applying the correct standard, wouldn't she know, though, I can't do that. I can't kick the can down the road to trial. I have to decide, and maybe would have been receptive to more evidence, knowing that she had to make the call.
And I mean, we can, I guess, speculate whether or not she would be willing to accept more evidence. But the idea that she applied the wrong standard does not equate to the state's argument that she would have reopened the evidence. She had received all the evidence. I think that the record shows she was a bit frustrated with the state because she kept granting continuances, and she kept warning them, okay, the next time we're going to hear evidence, you need to put on what you need to put on. You need to put on what you can put on. And so I think that's in the record. And additionally, again, at that last hearing, not only did the state put on what they could, which I believe was inadequate, but the defense also put on evidence. So I guess, and additionally, the only evidence it seems that the state could additionally put in, that wasn't put in, is the alleged victim's statement that it didn't appear to me 40 years ago or whatever, when I was 12 years old, that I was talking to a law enforcement official. That weighed against what the state did or couldn't do, and that testimony weighed against what the defense presented, in the sense that they presented police officers that said this is how things were done at the time, and that there were school resource officers, and that if a kid had been pulled out of class and asked about sexual abuse, there would have been a school resource officer there. And back at that time, nobody really took notes. I mean, they took notes, but nobody really, necessarily made reports. So just because there's no record of a report doesn't mean that there wasn't a report. All of that evidence taken together is still before this court, even assuming that Judge Streese would reopen the evidence. Probably the only thing that would be admitted, in addition to what she already has, is what the state proffered
So
from the
would-
alleged victim.
I want to make sure I have the procedural logistics right of this. After the defense put on evidence, did the state offer to put on the alleged victim
Yes.
as a witness in rebuttal?
Yes.
Okay, so it wasn't just an affidavit or a statement, it was, they would put her on, wanted to
Yes.
limit it to just this.
And, sorry.
Do you think that this is improper rebuttal?
In light, I would say yes, yes, in light of the history of the case. In light of the fact that at the very first hearing, they were talking about whether or not they were going to put on the alleged victim. Second hearing, she didn't put on the alleged victim, and I think that she represented, this is our evidence, I am not putting on the alleged victim. Third hearing, she again does not put on the alleged victim in her statement and just puts on the keeper of the records. Then, only after the defense puts on, it would have likely, been a school resource officer at this time, all of their evidence, then she comes out and says, okay, we'll put on the alleged victim. She is going to say this one sentence, basically, that she does not believe that she talked to a law enforcement. I'm kind of paraphrasing that. And the defense rightfully said, hey, that's not fair. You've had all of this time. Even if that, I believe it was improper, but even if it wasn't improper and that was admitted as evidence, our argument is that still does not show on the whole body of evidence, by a preponderance of the evidence, that a report was not made. And that would be the state's burden if the court finds that that is the state's burden. And in any offense, the court found that there was not clear evidence whether or not the statute of limitations had run or had not run. And again, that equates to us as her finding that she couldn't find by a preponderance of the evidence. And also, the court made some statement to the effect of, we also need to figure out, the elements of, or the factual circumstances about a report, whether a report was made. And so we'll just let the jury decide that. If we're still figuring it out, that means that sufficient evidence has not been presented.
What has to be presented in order for the state to have to prove this? I mean, we can't have the state just prove a negative, right, in a vacuum. I'm just wondering, here, as I understand it, we don't even have information about what the victim said allegedly during that conversation, right? We just know that she was asked about abuse. We don't know whether she confirmed that it occurred. Am I right about that?
According to the probable cause statement, I believe it was Detective Franco, she interviewed this alleged victim, and she said, when I was in, I believe it was 7th grade, this would have been 1988, I was pulled out of class and asked about the sexual abuse. I have not said anything about it. I believe she referred to Mr. Smith since then because it's been, so hard or something. So I think she did refer to Mr. Smith, and it indicated, it gave the inference that she had talked about sexual abuse from Mr. Smith with somebody. That's kind of I don't know the problem, but kind of one of the little nuanced issues that I think the court's going to have to grapple with is, first of all, under the statute, the defendant has to raise the issue. Mm-hmm. So what does that mean, to raise the issue? And is there any showing or burden on the defense in raising the issue to show that the report was made under those green factors? Or is that burden to then prove that a report was not made? And I think that the burden is on the state to show that a report was not made.
So do you think that any time that you have a crime charged outside, when it's charged long after the offense, that the defense simply has to say, we think a report may have been made at some point in the last 30 years, and then the state has to prove a negative that no such report was made during that time?
Standing here today, I would say that's not necessarily reasonable, that there has to be something like we have here, that this little girl talked to somebody about sexual abuse in order to raise the issue. Although my limited knowledge of civil law, most of the burdens and statute of limitations kind of come from civil law. And my limited knowledge of civil law is that they treat statute of limitations like affirmative defenses, and that's on the defendant to show that the statute of limitations is not run. Although I believe that there is some I don't know what the word is, presumption out there that if it's facially outside of the statute of limitations, then the plaintiff has to show that it is within the statute of limitations within their claim. That doesn't necessarily apply to criminal. It hasn't been applied to criminal. But it may be something to think about in a case where it's 50 years ago, 35 years ago, that maybe because it may clearly be outside the statute of limitations. And again, going back to the purpose of what a statute of limitations is, to prevent stale allegations from coming, that maybe if you're going to file a 35-year-old case, the prosecutor may want to ensure, or at least try and say, that the statute of limitations has not run. That wasn't your question, though. At this point right now, probably there has to be some showing, like happened here. We had some inference of a report. We are lucky in the sense that that woman said, I was pulled out in 7th grade. Because if she had never said that, then, kind of as the law stands right now in the criminal realm, there would have been really no showing that could have been made.
But let's say here that instead of the victim saying that she didn't recall a police officer being present, let's say that she did. How would we even know that this was a report? I mean, how do we know that she said anything that would have put an officer on notice that a crime had occurred?
Well, because she said that she talked about sexual abuse from Jamison Smith. So I guess that goes to the question that this court's going to have to decide, is when a defendant raises the issue, which we don't believe is onerous at all. We just believe it's like notice. But when the defendant raises the issue, are they required to show the green factors about, is this a report to law enforcement? Or is it simply sufficient, which we believe it is, to say there is what we believe to be a report. She said she talked about sexual abuse from Jamison Smith with a law enforcement officer. Here, we are raising the issue, and now shifts to you, state, to show by a preponderance of the evidence that the statute of limitations has not run, meaning it shifts to the defense, or shifts to the state to show that a report was made.
So here, though, from this record, we don't know. I mean, for all we know, they pulled her out of class, asked her about it, and she said, no, nothing like that ever happened.
Yep.
Right?
Not from this record, because in the probable cause statement, the detective says her statement was, pulled me out of class, I talked to somebody, I talked about sexual abuse, basically from Jamison Smith, and I had never talked about it since then. So at least we know that disclosure was about sexual abuse and about Jamison Smith, but we don't know who, we don't know where, we don't know when.
I think the probable cause statement, if I'm recalling correctly, is that she was asked about it. And the quote is, she remembers being pulled out of class when she was in 7th grade and being asked about the sexual abuse. CR stated she never told anyone else after that. So is that where you're getting the inference? That she told them at that time?
Yes, but I have the probable cause statement here. I'm sorry, I can find that. but-
No, it's okay.
But-
I think I just read the quote. So you're saying that that is enough of an inference that she did disclose something at that point?
Would the court, read the quote again?
Yes, it says, remembers being pulled out of class when she was in 7th grade and being asked about the sexual abuse. CR stated she never told anyone else after that because she felt ashamed of what Jameson had done to her.
Yeah. that's
Okay, so because she said never told anyone else after that, we're making the inference.
About what Jameson had
Right.
done to her.
We're making the inference that she confirmed that something had occurred at that time.
Because she was talking about sexual abuse. She admitted that she had been pulled out of court, talked about sexual abuse. But she didn't tell anybody after that because she was ashamed of what Jameson had done to her. So the inference is that she was talking about sexual abuse on the part of Jameson.
And that she confirmed it. I mean, that was sort of the point I was getting hung up on is I thought, well, if you've been asked about it and no action was taken on it, why are we inferring that she actually confirmed it as opposed to denied it?
Well, and that's the issue, right? So we know, and even if that's how the court is reading it, which is a great inference, but we know that she was pulled out. She disclosed, there was some kind of disclosure about sexual abuse with Jameson Smith. And is that enough for a defendant to raise the issue, put the state on notice that this may be an issue on a 35-year-old case, for the burden to then shift to the prosecution to prove beyond a reasonable doubt that this old prosecution should not be barred because it's too old?
And one of the things I assume that the state would then have to do, in your view, is put the victim on, if they don't think it was a report, and testify as to what she recalls telling someone at the time.
That could be one, that would, I think, be the easiest thing, but that woman or girl may not remember.
Certainly, but wouldn't we need to give the state the opportunity
no.
to do that at this stage?
Yes. I would think. But there's other things like the state did here, tried to review records. I mean, unfortunately, I get that this was old, but unfortunately, I think that initially the state was looking in the wrong systems, the wrong area. And the state could have done what also the defense did, was go back to some officers that worked around this time to see, I mean, they knew that she was in Eisenhower Junior High School. Go back to the school. Say, hey, back in the 1980s, did you guys have a resource officer here? Go back to the school and say, hey, do you have reports of these things? There was a lot of things that were done here. There were hundreds of tapes on microfiche that weren't even looked at. And I get that that is horribly time-consuming. But respectfully, guess what? If you're going to prosecute a 35-year-old case, you need to make sure that you're within the statute of limitations.
My question, though, and I'll just leave it here, but my question is, why doesn't this need to go back for a remand? I mean, did we even get to the point where the court was considering whether this actually constituted a report?
Well, yes. That doesn't make sense.
I mean, the last thing she says is there's case law that defines what is deemed to be a reporting
Right.
that should also be determined. So, I mean,
Right. I don't believe it needs to go back for a remand because we know what that alleged victim was going to say. And so you look at all of that, and this court can determine from all of that whether the standards have been met. The judge saying, I don't know whether a report was made or not. I don't know whether this fell within the statute of limitations or not based upon all these problems in the evidence. That equates in our mind that the state has failed to meet its burden to prove by a preponderance of the evidence that the the statute of limitations did not bar the prosecution.
And I know I said that was my last question, but I have one more quick one. I do worry about, the fact that the court had overlaid the sufficiently clear thing. And then the other thing I'm concerned about, though, is when she says it cannot be said as a matter of law. When we usually talk about that, what we mean is that no reasonable jury could find. So I'm just not sure when she says it cannot be said as a matter of law that the statute has run or not run. I'm not sure she's saying that the state hasn't proved it by a preponderance.
Right.
I kind of read that to say that maybe a reasonable jury could find either way.
Right,
And-
because that was the language from Pierce that she was
Right,
using.
right.
No,
So-
absolutely.
So why would we assume from that statement that what she meant was the state hadn't proven it by a preponderance?
Maybe we can't she made some other statements. I don't know if it was the beginning of that hearing, kind of what the standard was going to be. And she said something to the effect of, and this goes into misapplying Pierce and the standard, but she said something to the effect of, this isn't where I have to decide to dismiss or not dismiss. I can send this to the jury. So she takes evidence and then she makes that statement. Her statement that this, wasn't clearly sufficient, I get that that's more of a reasonable doubt statement. But I think that the record also shows that, and her findings also shows that she doesn't know whether a report was made. She doesn't know exactly what the court was questioning on, whether it met the green factors, all of that. That is the evidence, the body of evidence. So again, our argument is that body of evidence and her statement saying that, I don't know, or it's not clearly sufficient or whatever, to us equates with not finding by a preponderance of the evidence. But even if it doesn't, this court can still look at that body of evidence. That evidence, I would ask the court, if it's going to remand, not to let it change, not to let any more evidence be admitted. Maybe that one statement, if the court finds that it should have been allowed, let that one statement proffered by the state in. But that is the body of evidence. And if the court is going to remand, the judge and the parties should be bound by that body of evidence to make the determination whether that suffices to meet the preponderance of the evidence standard. Our view is that doesn't need to be done because it's a legal standard that this court can do because it's the same body of evidence.
The court said that it was a question of fact as to whether a report was made. Was she wrong about that?
Maybe not.
Okay, so
But
if that's the case, because that's why she felt like it needed to go to the jury, because there were questions of fact that needed to be resolved. So she wasn't viewing this as a purely legal question. She was viewing it as a factual question.
But I'm sorry.
So I was just wondering how it is that we would resolve those factual issues.
Well, there's a question of fact because enough evidence wasn't presented.
But isn't that a legal question, the sufficiency of the evidence?
I mean, I believe so. I mean, she's saying that there are still factual issues out there that haven't been presented to me in the context of this pretrial motion. There are factual questions that haven't been presented to me, which I'm going to throw to the jury. But unfortunately, those factual questions go to, right now, the sufficiency of the evidence in determining whether or not the state has met its burden in this situation. And I don't know if I answered your question.
I mean, I think you did. I'm just trying to figure out, it seems like she felt like there were factual disputes perhaps that needed to be resolved. And to me, that's not something this court should be resolving. It's something the district court should resolve in the first instance. I mean, she thought the jury should resolve those factual disputes. We obviously have resolved that question. But I'm just wondering if you either think she was wrong in the way she articulated what needed to be done, or...
She was wrong in articulating what needed to be done because she was applying Pierce. And so I think that when she said there's still facts out there that don't satisfy me, I can just throw them to the jury. But you're not resolving the factual questions. What you're looking at and what should be looking at if the court remands this is if those factual questions have not been resolved, that goes to whether or not the state met its burden to present and resolve those factual questions in order to meet their burden to show that the statute of limitations is not run.
Could not her mistake with respect to Pierce have played into her decision to exclude the victim's testimony? If she had understood that this was fully her burden, could it be said that she would have been more likely to allow that testimony?
I don't, and that's what the state has argued. I don't see the link. I don't see the link between her misapplying the burden in Pierce and thinking that she has discretion and excluding certain evidence under, I don't know, evidentiary rules or under fairness rules. I don't see the link there. But in addition to that, and I guess alternatively, we always have alternative arguments, right? If that evidence was allowed in, we know, the prosecutor proffered what it would be. So we know what it would be, and we know how it would affect the evidentiary picture that had been presented.
Can I push back on that just a little bit? I mean, she did sustain the objection to the proffer, right? But then she said she grants the defense's objection to calling C at this point in the motion. So it seems like she was granting that objection because of the stage of the proceedings, which, as the chief noted, she's anticipating sending to the jury. So it seems to me like, if anything, she was saying, no, we're not going to consider the proffer, but whoever's going to decide this question does need to hear from C.
And my response to that would be that at this point in the proceeding, we've had 5 hearings, and every time, the state tried to put on a little more evidence. And I believe the hearing just before that, the prosecutor specifically said, I am not putting on the victim. That is not going to happen. And then at the next hearing, presents all of their evidence, defense presents their evidence, and only at that point in the proceedings does the state proffer and want to put on the alleged victim. So the court is right. It could be read that she was thinking, I'm just going to push this into the jury, but it could also be read after this long history of you state not meeting your burden, after this history of you saying I am not putting on the victim, and then at the last minute when there's nothing else, then you're going to put on the alleged victim.
And that's fair, but given that ambiguity, shouldn't we let the district court make that determination if we were to remand?
I mean, the court absolutely could. But again, I would think that based upon the proffer, based upon what this alleged victim we think she's going to say, in the big scheme of things, again, the whole body of evidence, including what we think she's going to say, still does not meet their burden. That would be my argument to you.
I just have one question on the definition of report and what it means. So it's interesting how it defines it in terms of that it needs to be intended to communicate a crime to law enforcement, which seems like it's looking at the intent of the person who made the report. So I guess my question to you is there any, beyond the Green case, have you seen any other cases interpreting what we're supposed to be looking at in terms of a report to law enforcement? And this one is especially interesting because there's no evidence that anyone went to law enforcement intending to report it to them. It's sort of a passive, I was pulled out of class and asked about it and answered some questions. So how much intentionality from the reporter do we need that they decided, I want to report this crime to police?
I don't know the answer to that. I know that a Court of Appeals opinion, Toombs also dealt with what a report is, but I don't know if anybody has ever dealt with that there has to be an intent to report it. But I also think that it's interesting to note that under this statute of limitations, that the report had to be to a law enforcement official, which is different than when the statute of limitations was changed the next time, they said a law enforcement agency. And I know that doesn't go to your question, but I don't know about the intent, but also with regard to what I call the green factors, that also, I guess, then goes into I think this court has to clarify then, meeting these factors, showing these factors, or not showing these factors. Does that go to the defendant when they raise the issue? Do they have to deal with these factors at all? Right. Or is that part of the burden on the state to show by a preponderance of the evidence that a report under these factors was not made? And our argument is that making the showing of raising the issue in light of all the purposes of a statute of limitations should not be onerous. It should really not be much more than notice, saying we have this report, we had this disclosure back then, we think it probably would have been to an official of some sort, and then the rest of it is on the state. Because if they can't make this showing that a report was not made under these factors, then it's too stale, and it's not fair for anybody. Thank you.
Thank you, Ms. Taliaferro. Mr. Palumbo.
May it please the court, Michael Palumbo for the state. The parties agree that the court should not have sent the statute of limitations question to the jury. The parties agree that 76-1306 provides the procedure that the court should have followed. The court's confusion on this point was understandable. Both parties referred to Pierce and believed that it was controlling precedent. But to put it simply, the district court misunderstood its job description. It believed that when a statute of limitations question, when there was room for dispute, that a jury could be the ultimate fact finder. And this fundamental misunderstanding was a thread that ran throughout all of the proceedings in district court. The court, because of Pierce, was not looking at things with an eye to making a final decision. It knew that there was a safety release valve, and if this looked like it was subject to dispute, then it could send it to the jury. And crucially, this misunderstanding was very likely the reason for the court's decision not to hear from CR on the final day of the evidentiary hearing. CR's testimony likely would have been dispositive, and the court, knowing that the jury could be the fact finder, or believing that the jury could be the fact finder, may have declined to hear from CR, knowing that even if CR testified just to the limited facts related to the report, that could have opened up cross-examination related to CR's credibility. The district court could have believed that perhaps that might be a better question that the jury could answer. And so for a number of reasons, the district court may have justifiably sent it to the jury because of its misunderstanding.
What specifically happened in the back and forth between the prosecutor and the court when the prosecutor asked to put on CR?
So
in rebuttal, I guess.
And it's called rebuttal. The hearing, there was a lot of back and forth throughout all of the evidentiary hearings. The court, recognized that it was kind of an evolving question as additional evidence came out. The state tried to supplement the new questions that arose with additional sources of evidence. And then it was only after hearing from the defendant's experts that, the state kind of just close the coffin on the whole thing about trying to show that the records are going to be dispositive on the issue. And so at that point, the state had CR prepared to testify. The state proffered what they anticipated the testimony would be. And the state requested that the court hear that evidence to to allow the court to make a decision if it could, or send it to the jury if it cannot. And at that point, the defense objected. It objected both to the proffer and separately to CR's testimony. And the basis of defense's objection was kind of ambiguous procedural rules, claiming that it's just de facto always improper to allow this type of testimony on rebuttal. I think it's reasonable to think that this is not improper rebuttal testimony. The court or the state was trying to actually rehabilitate its case by calling an important witness. I don't think that on its own is improper, but also the court just has broad discretion in how to conduct proceedings. There's no authority that defense pointed to or that I could find that would have made that improper. And in fact, I'm thinking of State v. Bazunga, in which this court described the importance of, especially in pre-trial criminal hearings, to have wide discretion for a court to reopen a hearing and accept new evidence, even after the state has fully rested.
Okay, and so how did the judge describe her decision? What was her rationale for deciding to not let CR testify?
So the rationale, as Justice Pullman indicated, is, at this point in the hearing, I'm not going to do that. That suggests that, there will be another point in this hearing, and that point was going to be during jury selection. And also, just before the state proffered CR, the court indicated that it was already leaning towards sending the question to the jury based on the evidence that it heard. It had already, sort of surmised that this was the type of thing under Pierce where there's room for dispute and maybe it should go to the jury. And that's at record 1088. The court said maybe this is a situation where the evidence is not sufficiently clear that the issue needs to go to the jury. That's where the court is headed. So already the court, even before the state said, we have CR here, the court was already saying, I'm leaning towards just sending this to the jury so that we can move on with other matters. And
I'm sorry, did he answer your question? Can you tell me what your response is to, and I realize we may not have to reach this, but I am curious about this question because it was raised in the defense's reply brief in footnote 9, and then again here in argument. The defense thinks that if the court finds by a preponderance of the evidence that a report was not made, that it then also goes to the jury, the statute of limitations issue. What's the state's position on that?
So I want to make sure I understand that question. So the argument is that if there's evidence that a report was not made, that it could go to the jury?
Yes, that if the state did meet its burden to establish by a preponderance of the evidence at this point that it's not time barred, that the issue should still be sent to the jury and that the state would have the burden at trial to establish the prosecution was within the statute of limitations beyond a reasonable doubt.
The state disagrees. Section 306 clearly defines the role of the court in deciding a statute of limitations question. I don't necessarily disagree that it's possible that a statute of limitations issue may not arise until trial. And at that point, I think it would be expected that a defendant could raise that defense, but still under Section 306, it would be up to the court to decide. It wouldn't receive a jury instruction and send it to the jury. That's the legislature has said that is not how statute of limitations questions are decided.
So even if it was raised at trial, it would still be the court's obligation to make that determination. It would never be sent to the jury, is your position?
Yes, Section 306 is unambiguous on that.
Okay.
Can I ask a question that I realize is not directly in front of us, but it impacts how I think about this case? So I come from a civil background. Defendants have to prove statute of limitation defenses, right? That's their burden to show. And so I understand that this court below was bound by Pierce, which said this is the burden of the state to prove. But they begin by saying that's because the state bears the burden of proving every element of an offense. I don't understand the time to be an element of a defense, so I'm not really sure if I understand Pierce's reasoning, they also rely on a jurisdictional question, but it seems to me to be suggesting a very limited showing that has to be made by a state in order to show that, yes, we're within a jurisdictional boundary. So I guess I'm just curious, and in part, not necessarily that I'm deciding this issue in this case, but I'm just curious about the way we talk about this. Is it the state's view that this is correct, that in fact, this is a defense that if raised by the defendant, the state has the burden to show that the statute of limitations is met?
No, the state disagrees with that. Because Section 306 superseded Pierce, it superseded Pierce entirely. So Pierce was decided based on reference to other states who viewed the statute of limitations as a jurisdictional bar. This court has not definitively ruled on that issue, but in State v. Stewart, this court did favorably refer to State v. Jackson, a Court of Appeals opinion, in which the Court of Appeals extensively discussed whether the statute of limitations is jurisdictional or not. In the case of Stewart, it was in the context of a defendant is able to waive a statute of limitations defense, strongly suggesting that it is not a jurisdictional bar. So the first response to your question is that the Pierce rule that said it's the state's burden to prove is also superseded by Section 306. The state accepted but did not concede this point in its brief, and in candor did that just out of expediency to address the key issue of what the governing authority is. But upon further review and in preparation for today, I understand that that is an important subsidiary question. So Section 306 on its own seems to suggest that the defendant has the burden of demonstrating a statute of limitations defense. And I think that's further reinforced by the length, especially in a case where it's reporting, where State v. Green would apply, and it seems like the defense would be the one to prove affirmatively that there is a report made for the purpose of notifying law enforcement in a way that law enforcement is on notice that an offense occurred. That seems like a positive thing that a defendant would have to prove. It's not phrased in the reverse that someone has to prove that a report was not made. And the same is true of 306. The court has to decide by preponderance whether a statute is barred by a statute of limitations, not that the court must determine that the statute of limitations defense is not barred, or a case is not barred by the statute of limitations. So I think just a reading of that plain language suggests that it should be the moving party who has the burden of proof
Don't we have other statutes that address this? Who has the burden of proof in a criminal case when an affirmative defense is raised?
Yes. And in defined affirmative defenses like entrapment, the statute provides a procedure for doing that. And so you could, so in some situations, like in entrapment, once the issue is raised, at that point, an evidentiary hearing can be set, and then a trial, because it's an actual defined affirmative defense, the state would have the ultimate burden of disproving that affirmative defense beyond a reasonable doubt at trial. But those are all defined affirmative defenses.
Okay.
Statute of limitations has been treated a little bit differently. In Section 306, the court decides, presumably pre-trial, but not necessarily, by a preponderance, and that's the sum total of the procedure.
So back to what Justice Pullman was saying, though, what's the state's position in terms of whether the statute of limitations is an affirmative defense?
It seems not like a defined affirmative defense, but it has a lot of similarities. It's an affirmative defense because it doesn't depend on a defendant's guilt or innocence.
It doesn't negate an element of the offense.
So in a colloquial way, I think it's fair to think of it as, a lowercase a affirmative defense, but it's not an affirmative defense as defined by statute with its own procedure, and that then puts the burden on the state at trial to disprove it beyond a reasonable doubt.
I guess my concern is if the state's asking us to remand, do we need to provide some clarification to the district court about whose burden this is?
I mean, of course, the court can do that, but I also think the district court is capable of reviewing the plain language of the statute itself and making those initial determinations.
Okay.
Have you argued that it's not your burden? Below, is that preserved at all?
It is, I believe below, in district court, the state, believing that Pierce was controlling, accepted Pierce's statement that it's the state's ultimate burden to prove that the statute of limitations does not bar the prosecution. And so ultimately, what the state is asking in this case is a remand to the district court with instructions that State v. Pierce does not apply. Section 306 is the governing authority, and that make it clear that the district court has discretion whether to conduct further proceedings or open evidence again. And the support for that, again, is in State v. Bazunga and the important societal interests in adjudicating felony cases on their merits, especially when there are pre-trial, potentially dispositive motions in district court.
One quick question, just to make sure I understand how this works. I think I understand our case law on this. The reason that this case is not simply barred by the statute of limitations in effect at the time that said that you can't prosecute after 8 years is because, assuming no report was made, the legislature extended the statute of limitations before it expired, correct?
Yes, that's
Okay,
correct.
all right.
Yes, and it seems from the briefs, I think both parties agree that if no report was made, of which there's no indication that it actually was a report, then the statute of limitations would have been extended by all the legislative extensions until 2008, when the statute of limitations was eliminated entirely.
And the reason why we can apply that is because there was never a point at which, assuming no report was made, that the case was barred.
Correct. That's correct. And just a note on, particularly in child sex abuse cases or in sex abuse cases, the policy that informs not having a statute, I think, is important to keep in mind too. It's not that, child sex abuse is generally between two parties, and so staleness of evidence and missing important witnesses is less of a concern when the primary evidence is going to come from a single victim. And unless there are any additional questions, the state would ask that you remand on the terms that I described earlier. Thank you.
Thank you, counsel.
So I think the court is understanding a little bit of the nuances. What I'm asking the court to rule, I guess, and clarify is, first of all, under this statute that came in 1998 that the state is relying on, what is the burden of the defendant to raise the issue? The statute says when an issue concerning statute of limitations is raised. It doesn't say, like in the justification statute, that to raise an issue you have to make a prima facie claim or anything like that. You just have to raise the issue. That somewhat equates with other pretrial raisings of issues, that you just have to put the person on notice that this issue is out there. And then what is the burden on the state? And the court is right, and the way the parties have argued this, we just all assumed that the state then has the burden. But the statute doesn't say that. The statute says when the issue is raised, then the court must find by a preponderance of the evidence. It doesn't lay out like in other statutes, like in the entrapment statute, like in the justification statute. The defendant has to do this, and then upon doing this, then the state has to do this. That's not what this statute says. I can argue that I believe that it should be the state's burden, but that's something that the court's going to have to determine.
That's my question. Do we have to determine it here or not? If we do have to determine it here, I can say, just speaking for myself, that I might want supplemental briefing on that issue.
I think the world, the Utah world probably wants clarification on this issue because it has not been, it's not out there. But the court may not need to reach that issue because based upon the evidence before the trial court and now before you, our argument is that does not amount to a preponderance of the evidence. And that body of evidence was not only submitted by the state, it was submitted by the defense too.
So do you think that there's a possibility that going back to the district court, that the district court could rule regardless of who had the burden of proof?
Yes,
Okay.
yes, absolutely. And then also just in.
Can I just follow up on that?
Yes.
But is there a strong probability that it could also go the other way? I mean, we can envision it going that way, but can we be confident that is the way it'll play out and that the burden won't play a role below?
I think that you can be confident just because, again, if the defense had not put on any evidence and just relied on the state's evidence, then that would be more so, well, the prosecutor didn't meet their burden, so we win. But because the defense also put on evidence and there's this body of evidence, it didn't matter who put on the evidence. Before the court was a bunch of evidence that the court could then, under the rule, determine whether or not by a preponderance of the evidence, whether the prosecution was barred. So on this case, because both sides presented evidence, the evidence is what it is, and there's really nothing more out there other than perhaps the alleged victim's statement that she didn't know.
Right. That's the thing I'm worried about. I mean, let's say this goes back and the district court declines to reopen the evidence. Whether or not a report is made, I think that's going to turn on whose burden it is, right?
Well, I don't think so, because if that evidence is not before the court looks at what the evidence is.
Okay, but what we know is she was asked about sexual abuse and we
Right.
don't know what she said.
Right.
So,
And so if
boy,
that's
that
not
seems
there,
like, if that's not there, if it's the state's burden,
if-
then that's going to be cut against the state. But if it's the defense's burden to show that a report was made, that's
Well,
going to cut against the
I mean,
defense, isn't it?
If that's not there,
Uh-huh.
then the court cannot determine, no matter whose burden it is, if that piece of evidence is not there, the evidence is what it is. And if that's not there, can the court determine by a preponderance of evidence whether the prosecution was barred? It doesn't matter. It's just the court looking at the body of evidence and determining whether on that body of evidence there's a preponderance of evidence, no
Does
matter
it-
who put it in.
Does it mean something? I hate to get
No, you're-
this focused on the words.
No,
but-
I know, this is why
but-
I've confused myself as well.
But when it says determined by a preponderance of the evidence whether the prosecution is barred, that seems like maybe there's a significance there, that it's
I agree.
not determined by a preponderance of the evidence whether the prosecution is timely. I just wonder if that makes a difference in terms of whose burden it is.
And I don't think so, because statute of limitations have been referred to in case law as a number of different things, as a bar to prosecution, as a jurisdictional bar to prosecution, and also as affirmative defenses. So I believe that that is meant to say whether or not the statute of limitations, the applicable statute of limitations, bars the prosecution. Words are important, so that's why I think the burden is not on the defense to show that a report was made in raising the issue. I believe that the burden is on the defense, or on the prosecutor, to show that it was not made and that they are okay to proceed.
But I guess as a fact finder, I might look at that and say, can I find by a preponderance of the evidence that this was barred? No, because I don't know what was said.
Right.
That seems like it's going to put the burden on the defense, though. to show that it was barred, not on the prosecution to show that it was not barred.
Well, and again, this is why I confuse myself. No, absolutely. But and that's why I am saying that I think that even though it doesn't say that the issue being raised, this represents kind of a burden shifting scheme, even though, statute, even though it's not specifically laid out. When the issue is raised, and that's usually by the defense, then the burden should shift to the prosecutor to show it. Now, that's not what the statute says, right? And I get that. But again, in light of the statute of limitations sometimes being called an affirmative defense, and at trial, going back to Justice Pullman's question, at trial, if this was brought at trial, affirmative defenses become elements of the crime to be proven beyond a reasonable doubt.
Do they though, or is it only affirmative defenses that negate an element of the crime, like justification? Because does it make a difference whether it negates an element of the crime?
I wouldn't think so, but I guess my thought about bringing that up is that the state has indicated, and I know I'm jumping around, the state has indicated that 306 says the judge has to determine it. There's nothing beyond that. If the judge doesn't determine it, then this isn't an issue to be raised at trial. And I disagree with that, because similarly, the justification statute. We didn't have a justification statute until just recently. I want to say 2020, 2021. And before then, and when that statute was put into place, they put in procedures. And that statute now says by clear and convincing evidence. And if that's not proven, you still get to have the jury find it beyond a reasonable doubt. So that just goes to the question that you probably didn't ask me. But if for whatever reason it is found that the evidence was sufficient, I would urge the court to, yes, find that it could go still to the jury if necessary. And I would just indicate again that we believe that a remand is not necessary, that the same body of facts is before this court that would be before the trial court, and I'd ask the court to clarify the law a little bit. Thank you.
Thank you to both counsel. We do appreciate the briefing and argument in this case. And we will take it under advisement